Good morning, ma'am.
Good
morning, ma'am.
Okay. So
Good morning, ma'am.
Good morning. So this is the first class for corporate law. So we'll be beginning with it. So we are in total almost about 70 people. So at any place of time there is any problem with regards to hearing me out, then do tell me, because there might be some technical glitch in that. So in that case, I will change my internet facility. So before I begin, does anybody have any idea about corporate law? Just raise your hands. No need for answering. Okay. So there are few who are saying yes, and there are few who are saying no. I'm trying to connect my PPT. Just a sec. I would request all of you to please kindly switch off your videos. I'm not able to connect my PPT as such. Try. Anyways, if I'm not able to connect my PPT today, tomorrow I'm going to do it. I'll proceed with the class now. Okay, if we look at
Good morning, madam. Good morning, madam. Sorry. This is Pinaki Chatterjee. May I know whether your PPT will be served in our group, MBA group?
Yes, it will be served, but I'm not able to come out with it right now. Okay.
Okay.
But
okay.
If not today, then definitely within a couple of days, I'll be sending it to you.
Actually, madam, due to my busy schedule, actually, I am in ICMR, Indian Council of Medical Research, Government of India. So I have to frequently visit outside Delhi and other cities. So I may not be able all time to join these classes. So my heartiest request to you and all faculties to share this PPT over our WhatsApp group so that we will be able to catch it.
Definitely. I'll definitely do it. That's why I said, Mr. Chatterjee, that if not today, then definitely within a day or two, I will be sharing the PPT with you.
Sure. Okay? Thank you, ma'am. Thank you, ma'am.
Because I'm facing technical problem, so that's why I'm not able to do it.
Sure.
Anyway, so let us begin with Companies Act. So the Indian Companies Act was framed in 1956. Okay. So today's class, I'm not able to share the PPT. Please kindly bear with me. So from tomorrow, I'll be ensuring that the technical glitches are not there, and we'll be able to view through the PPT. Okay. So I'm just kindly listen to me, and if there is any issues with regards to, if you don't understand me anywhere, then you can stop me. So let us look, before we proceed, so let's have a look at the syllabus. I hope everybody has access to the syllabus. Okay, so in the first unit, you are having Introduction to Companies Act 2013, wherein some important definitions and concepts, and then formation of the company, which will include Memorandum of Association, Articles of Association, and then few of the companies like government company, then key managerial positions we are going to discuss, and one-person company, private company, promoter, and prospectus. These are going to be covered in the first unit. But before we move into the introduction of Companies Act 2013, so let us look at Companies Act 1956. So before 2013, it was preceded by Companies Act 1956. So from all practical purposes, the Companies Act 1956 was based on accommodation of the Companies Law Committee in 1952. So in 1952, when the Companies Law Committee, whatever recommendations they had given, the Companies Act 1956 was framed according to it. Okay. So the basic objectives of Companies Act 1956 was to help in the establishment of the companies, and also to ensure the rights and interests of the partners, and to ensure that the shareholders have the maximum say, to ensure that the affairs of the companies are managed in a consensus manner. So overall, to ensure that the company is performing to the best of its ability, and the shareholders' interests are protected, the suppliers' interests are protected. Taking everything into consideration, 1956 was framed. And after that, there have been many amendments to the Companies Act 1956. Okay. Now, in 2013, the new Companies Act was basically, it was an act of the Parliament of India, and it is divided into 29 chapters. The 2013 Companies Act, which is the new Companies Act, it is divided into 29 chapters, which has about 470 sections and 7 schedules. Okay. And which replaced the Companies Act 1956 after it got the assent of the President of India. So any act to be enforced, as you all know, it has to come with the assent or the affirmation of the President of India. And the act came into force on 12th September 2013, with certain changes, like earlier private companies, maximum minimum numbers changed. Okay, so few of the changes came into place with the act. So as we proceed, what I'll do is I'll be telling you about the changes in what changes have taken place in the act, and how vis-a-vis 1956, what was there in 1956, and what happened in 2013. Okay. So now let's moving forward. Just a second, please. A little bit of problem with. Just a second, please. Okay. Now let's come to the definition of a company. What is a company? A company is basically an artificial person which is created by law, and it has a separate legal entity. So I told a few jargons. I told one is artificial person. I told separate legal entity. I told, and yes, of course, a company has a perpetual succession, and a company has a common seal. So I want everybody to write down these words. One is artificial person, one is perpetual succession, one is separate legal entity, and one is a common seal. What are all these things that I'm talking about? Okay. Now we all are natural.
Ma'am, please repeat again.
Yeah. One is artificial person. Okay, you can write down the definition. A company is an artificial person created by law, having a separate legal entity, with perpetual succession and a common seal.
Madam, created by law in?
With perpetual succession, having a succession, and having a common seal.
Having a common क्या है मैम?
Common seal, S-E-A-L, seal. Let me use the, I don't have the whiteboard out here. Anyways.
Madam, can you please repeat the definition once again from the beginning?
Yeah. A company is an artificial person
Yes, ma'am.
with created by law, artificial person created by law,
Yes.
having a separate legal entity with perpetual succession and a common seal.
Thank you.
Okay. So the
Yes,
first one that I told you was artificial person. Okay. Now, if you look around, you see many companies. Okay. Now, when you look at, let's take the example of Tata. If you look at a building, there you will find that, okay, this building belongs to Tata. Okay. So what is that? That building has become an asset of Tata. I hope all of you understand what is an asset, what is a liability, all these things, you know, because these are the terminologies which we will be using. If you don't know, then I can explain that also, because these are the basic elements of commerce that you have to know. Okay. So Tata has got a building. So asset is anything that the company owns. Okay. So Tata has got a building. So that is the asset. Now, when we are looking at Tata, so when we take the name of Tata, what comes to your mind? It is Mr. Ratan Tata that comes to your mind. Okay. But is Mr. Ratan Tata equivalent to Tata company? No. Mr. Ratan Tata is not equivalent to Tata company. Tata company is a completely separate legal entity, or it has got its own identity. Okay. So company is an artificial person. We all are human beings. We all are natural person. So a natural person will own assets. We will take loan and have liabilities. So we will do bank transaction. We will purchase things. We will sell things. All these things are done by the company also. So the company will also purchase assets. The company is going to take loans. The company is going to have its own legal, and the company will sell the product. The company is going to purchase products. So that is why we call it an artificial person, because it is not a natural person like all of us, but it can do transactions like all of us. So that is why it is called an artificial person. So that is the meaning of the first jargon. Company is an artificial person. That means a company can own things, can buy things, can have assets, can have liabilities, but exactly like a normal person, but it is not a normal person. You cannot see or touch or feel a company. Okay. You only recognize a company from its name, its logo, all these things. Okay. So that was the first jargon that I told you. Point is separate legal entity. Separate legal entity means it has its own identity. So when we are talking about Tata Group and Mr. Ratan Tata, both are two different things. Company is a separate legal entity of its own, which is very different from Mr. Ratan Tata. So a Tata Group has got various companies. Each company has its own identity. So Tata Motors, it's not the same as TCS. And all of them are not equal to Mr. Ratan Tata. So every company has their own identity. Okay, and they are created separately. That is why they are having a separate legal entity. Okay. Then is perpetual succession. Third, I told is perpetual succession. Perpetual means forever. Succession means it will go on existing forever. So here I will take the example of Reliance. So Reliance company was founded by Mr. Dhirubhai Ambani. Okay. When Mr. Dhirubhai Ambani died, did Reliance company die? No, it is still existing and the business is going on with the under the chairmanship or leadership of Mr. Mukesh Ambani. So that is called perpetual succession. So it does not matter whether the persons who have founded the company, the persons who started the company are alive or dead or whatever is happening. The company, because it has got a separate identity of its own, will continue to remain or will continue to exist forever. Okay. And the fourth jargon is common seal. Okay. So common seal means we all, natural person, we all sign. So the company is an artificial person. It cannot sign. So the people who are managing the companies, how do they give the assent or the confirmation or the yes of the company? It is through a seal. The seal signifies the signature of the company, and every seal is different for every company, which is unique to its own company, just like its name and logo. Okay, so that is the definition of a company. Okay, any doubts, anybody? Understanding any of the jargons?
Yeah.
Ma'am,
No,
please
ma'am.
repeat last
No.
one.
Common seal?
Yes, ma'am.
Common seal means a seal is like a signature. So, like for example, we people, human beings, we have our signature. Okay, so when we are signing, then we do the signature over there. But a company cannot sign. So a company has got a seal of its own. So all the dealings that the company does, all the transaction that the company does, for that the company uses its seal. Okay, so instead of using, so that is basically, it is representing the signature of the company.
Is it same as brand?
No, it is not same as brand. Brand is the value or something that we identify it with. Okay, seal means the signature.
Logo.
I'm sorry.
It may be a logo. The signature.
Yes. Logo is what you see. Okay. Seal is what is affixed on the documents. Okay. So whenever the company has a document and it has to be signed, supposing Tata is entering into a MOU with Reliance, so the people have to sign over there. So the managing director puts his signature and the company seal is put. So the company seal is unique for every company. Okay. It is basically representing the authority of the company, which is affixed in all the papers of the company. Okay. So if you have passed your all your when you see your documents, okay, so you will find the authorizing. If you see the if you have got your certificates, examination certificate, then the controller of examination seal will be there. So that if that seal is representing the authority of the person. So in the same way, a seal, that seal represents the authority of the company. Okay. Another word that you need to write down is limited liability. Okay, for a company, limited liability. What is limited liability? So limited liability, supposing let us look at a pan shop or a chai shop. The person who is starting the shop or the person who is selling or the vendor who is selling, supposing he makes losses, then the entire, he has to close down the entire shop because he is the single person who is responsible for the business. Okay. So his liability is unlimited. So today, if I open a business, I'm the only person who has opened the business. Whatever profit I make, that profit is all mine. I don't have to share it with anybody. But whatever losses I make, that losses is also mine. And if the losses is beyond the business, that means I sell my business, I sell the assets of my business, still the losses are more, then I might have to sell my personal assets also, my house, my car, my gold, my jewelry, whatever it is. I have to sell and pay back to the persons or the creditors who have given me money. But in case of a company, if I am the shareholder of Tata, if I'm having shares of Tata and Tata is facing losses, then my loss is only limited to the value of the share that I am having. So my amount that I have to pay will only be limited to the shares. I don't have to sell my house or property to pay off Tata's loans. So that is why limited liability is another characteristic of a company. Okay, which is unique to the company, which is not found in case of sole proprietorship or partnership. Okay. And there are different types of companies like private company, public company. Then you are having one-man company, one-person company. So these are things which we will be doing after we complete the procedure for registration, how a company comes into shape or how a company takes birth. Okay. So for the formation of a company, there are certain steps. One is promotion, then is registration, then is certificate of incorporation, then certificate of commencement. So I want you to write these down. First is promotion, then is registration, then certificate of incorporation, then certificate of commencement. Please write these down. Promotion, registration, certificate of incorporation, and certificate of commencement.
Ma'am, what are these?
Okay, I'll come to, these are the different steps for the formation of a company, which is one part of your unit 1.
Ma'am, the definition can be the common sale is may or may not be if company have the common sale, because as per the amendment of 2015, companies don't need the compulsory or common sale. They can may have or may not have.
Absolutely, absolutely. You are absolutely correct. They may have, they may not have, but most of the companies in India are still having and working with the common sale because it has been a practice with them. Because we are moving towards more of a digitalization of all the aspects. So that is why this provision has been introduced so as to make digitalization more, or the working through digitalization more convenient. Okay.
Thank you, ma'am.
Okay. So let's move to formation of a company. Just give me 1 sec. There is an important call. Let me just attend to that call.
आप म्यूट करो, मैं तो आपका आवाज.
Okay, thank you so much. Sorry for the delay. There was an urgent call. Okay, So now we move to the stages of formation of a company, or how a company comes into form. So there are 4 stages basically. One is promotion, one is incorporation. Then you get the certificate of incorporation. Then you go on to get the certificate of commencement. Okay. So I will cover, just a second. Has somebody written something in the chat? Okay. So we will cover at least the formation part for today, and then we'll move to the others in next class. Now let's come to first is promotion of a company. So the promotion of a company basically is the first stage towards the formation of the company. Okay. Promotion means in what way you are going to start with the process of justice. Sorry, one second. Okay, so promotion can be defined as discovering of business opportunities or ideas to bring about a new concept into the market, to bring about new ideas through the shape of a company. Okay, so the stages of promotion includes, first is discovery of idea, then detailed investigation into the idea, assembling of the propositions, that the idea that you have got, assembling those idea, then the financing proposition. Okay, so basically discovery of the I am sorry, Anushka, but I cannot help in any way. If it is denying more than 100 participants, that is not in my hand, because Zoom as it is has a limit of 100 participants. Okay. So I cannot. Now somebody has written over there, use this link, ma'am. Okay. Okay, fine. Okay. So what is discovering of the idea? Now you see a lot of startups coming up. You see a lot of companies coming up all around. So how do they come up? If you look at Swiggy, Zomato or anything, what is that all about? It is basically the idea that has come into the minds of the people to do something new, to do something different. Okay. Once you have got this idea, the next is investigation. Investigation is basically whether the idea is feasible or not. Okay. Whether the idea will work out or not, because everybody comes up with idea. Not every idea is very feasible. Okay. And then if the idea is feasible, then assembling all the things required, right from the people who are going to work, the finances, everything, that is assembling of the propositions. Now, the person who actually frames it, who takes all the steps, or who does all the hard work for establishing the company, is called a promoter. Okay, so a promoter is basically a person who undertakes to form a company for the betterment. Nowadays we basically say for the betterment of the society and all, but promoter is a person who assembles the men, money and other required things to form a company. Okay, so a promoter is the person who gets the original ideas, okay, who gives shapes to his ideas for promoting the company, who proposes or takes into account the entire steps towards building that company or that idea, or giving the reality to his idea. He is a promoter. Now, promoter's legal position, if we come to what is the legal position of a promoter, then promoter is, he starts working in a company before the company has even taken shape. So when a company has not taken shape, what is the relationship between the promoter and the company? Okay, so if you have read about business law, I think everybody has read business law before coming into corporate law.
Yes,
There is, okay, good. So there is something called contract over there.
yes.
Law of contract. Can anybody tell me what is a law of contract? Basically, law of contract says that an agreement between two persons which is enforceable by law goes on to become a contract. An agreement enforceable in the court of law goes on to become a contract. Okay, so it takes into account agreement between two people which is enforceable by law. So to be enforceable by law, both the persons should be existing. I cannot enter into a contract with an unborn person or a dead person. Okay, so when we are talking about a company over here is yet to take shape, but the promoter is working on behalf of the company to form the company. So that is called a fiduciary position. Fiduciary, fiduciary position, or a position of trust. Because before even the company has taken place, the promoter will enter into various kinds of preliminary contracts. Okay, so that is why these preliminary contracts, if we go by the law of contract, then they won't hold valid. They will not hold valid in the eyes of law. Okay, but if you look at if we are looking at the relationship between the promoter and the company, then Lord Cranes has said that the promoter enjoys a position of trust and confidence during the formation of the company. Okay, it is the promoter who enjoys, who decides what will be the shape and size of the company. The promoter will be engaged with starting the company. So the promoter is basically, oh, did my video get switched on? Okay, so the promoter is basically a person who is in a fiduciary position or a position of trust with the company. And because he is in a position of trust and he will be entering into various, please keep yourselves muted. Please do keep yourselves muted during the class. If any doubts, then only you can ask. Okay. So basically the promoter, because he is in a fiduciary position, so the promoter cannot make any profit out of the company. If it does, then it has to disclose. The promoter cannot purchase from the company's money. They cannot purchase any assets for their personal use. So basically they are in a position of trust. But the promoter has got certain rights which have been given by the law to the promoters, because as it is, the promoter is working for something which is still non-existent. Okay, and they are in a position where they have to bind the company with their work that they are doing. They have to bind the company with their with all the activities they are doing. Okay, so the promoter has got the right to enter into to get legitimate preliminary expenses. So what are preliminary expenses? So preliminary means initial. So when the company is being formed, the initial expenses, the initial work, the promoter has to incur. Okay. So before even the company comes into existence, the promoter has to incur various expenses. They will be incurred so as to bring this company into legal existence. So the question here arises, so can the promoters of the company actually legally claim the expenses that they have incurred during the time of promotion, because they are doing it for an entity which is not existent as such till now? Okay, so that will depend upon the, as per the law, the promoters cannot sue the company, because once they have incurred all the expenses, they cannot sue the company for the preliminary expenses they have incurred. Okay, so that is not the right. Because why it is not right? Because we will go back to the Contract Act. So both the when there is a contract, both the parties have to be existing. But here only one party, that is the promoter, which is existing. The company is yet to take shape. Still the promoter is going to incur the liabilities or the expenses for forming the company. So as such, the law is telling that the promoter cannot sue the company. The promoter does not have the legal powers to sue the company, because there was no contract between the company and the promoter. But it will depend upon the company's decision. Even if there is no such provision in the articles of the law, in the articles of the company, but there is deemed to be, because there was no contract between the company and the promoter, but yet in the normal practice, the policy is that in such a situation, the company will pay to the promoters all the expenses he has incurred. That is the normal practice that prevails in the in the general company. Otherwise, why should somebody promote a company? Why will somebody incur all the preliminary expenses? They can, because that is they are working for the formation of the company. They can, but there is no legal binding. The law is not saying that you have to pay. Okay. So there is a very famous case. Just write down. I want all of you to find out about the case, so that you can tell me about that case. Let me write down in the chat box that case name, so that you people can refer to the case. And if you don't understand, you are going to ask me. This is a very famous case. Did I send it to everybody or just to one person? Just a sec.
Ma'am, send it to everybody.
Yeah, I'm doing. Did everybody receive?
Yes, ma'am.
Just go through this case, all of you. I want all of you to have a first-hand information. If you don't,
ma'am, not received.
Not received.
Yeah,
Okay, whoever has received this, please kindly post it in the group chat so that everybody can receive it.
Madam, I have a query.
Yes.
Can I say? Actually, in this occasion, a company is going to be constituted or set up, not having any legal separate entity. And in the occasion, the promoter is not discharging his liabilities properly or fully. Who will enforce him to do so, or who will take penalties against him for doing not such activities?
See, when I was defining what is the legal relationship between the promoter and the company, I told you it is a fiduciary relationship. Many judgments have been passed on the basis of fiduciary relationship. Okay. So because the promoter is in a fiduciary relationship, so if he has made any secret profit, or he has, what do you mean by not delivering the services properly? Can you elaborate what exactly you want to say? What exactly?
Taking the process for registration of the company, or submission of preliminary documents with the registrar of the company.
Okay.
Like
Okay, understood. So section 34 of the Act makes a promoter criminally liable for different misstatements, false or untrue statements in prospectus. Okay. And if the promoter has conducted any fraud or any breach of duty, that means they are breaching their fiduciary position, then the court may restrain the promoter from taking part in the management. Okay. Section 339 has also specified about the penalties to be imposed on the promoter. We'll be coming to that. Okay. After the rights, we'll be coming to all the liabilities of the promoter. Yes.
right.
The promoter may not be, the company may not be existing. The company may not be having a separate legal entity. The company may not be in existence, but still the promoter is the person who is promoting the company. The promoter is the person who is starting the company. So the promoter, the moment the promoter starts his job, he enters into a fiduciary relationship with that non-existing company till the company comes into existence. So any kind of fraud or misdeeds, if the promoter has committed, even if there is non-existence of company contract act, but the company law has specified criminal charges and other charges for the promoter. Okay.
Right, madam. Right, madam. Thank you, madam. One more.
Yeah.
On behalf of the proposed company, who
I'm
will
sorry?
make on behalf of the proposed company to be constituted? Who is the authority to make the promoter as in a fiduciary relationship? There is a fiduciary relationship. So someone has assigned him that fiduciary relationship.
Okay. The fiduciary relationship has been assigned by the law. Nobody is assigning. Who can assign? Because the company has not taken shape yet. So the people who are going to run the company, that are the board of directors, the managing director, they have not been constituted yet. They have not come into existence yet. So how does the promoter come into a fiduciary relationship? It is because of the law. The law has made it mandatory, or the law has said that the moment a person steps forward to form a company, the promoter enters into a fiduciary relationship or a relationship of trust with the company. Okay, I'll wrap it up very fast because we have a meeting exactly at 10 o'clock. Okay, so I will, it's, okay, so it's 9:47. So by 9:55, I will close because I have to join the meeting at 10 o'clock. Okay. So when I told that the promoter has got the right, although not the right, he cannot claim, but because he has worked in a position of trust for the formation of the company, so whatever preliminary expenses has been incurred by the promoter, the company usually, on the ground of trust, they usually pay back to the promoter. Another is the right to get proportionate amount from the co-promoters. So supposing there are more than one promoter at the time of promotion of the company. Okay, so they are called co-promoters, and one of the promoter has incurred the expenditure. So he is entitled to be proportionately reimbursed, excuse me, proportionately reimbursed by the other promoters who are working together to promote the company. Okay. So what you have to bear in mind here is that the promoters are also individual and separate. So every promoter over here, each and every promoter will be personally liable if they are making any secret profits in the process of promoting. Okay. So if one promoter has to reimburse the company for any secret profit, the other promoters are liable to proportionately pay their share for such an amount to this person. Okay, so that means if this person has made any secret profits and he is paying it back to the company, so he can get it from the other promoters also. Okay, so here a question might arise that if one promoter is saying that I have not been a part of the secret profit. So here the onus of proof lies with that promoter to prove that he was not a part of these secret profits that are made. The law is very fair. The law will say that all the promoters are equally involved. So if any person is saying that I am not involved in any way with the secret profits made by the company, then we say the onus of proof. The onus of proof lies on this promoter to prove that he is completely innocent. Okay. And another right is, so we have learned about the right for legitimate preliminary expenses, the right to get proportionate amount from the from other co-promoters. Another is right of remuneration. So basically the promoters, we can, when the company is non-existent, so the question of remuneration does not come into picture. But the law is saying that when the promoters have worked so hard and they have performed for the formation of the company, then they are remunerated, they can be remunerated by the company for their efforts. So the remuneration for the promoters can, for the in consideration of the services that they are rendering for the formation of the company, it can be in the form of cash, it can be in the form of partly in shares also, in debentures also. So the company might also buy from the promoters. The company can also buy from the promoters the some of the property which they had bought for the company. Okay. Or usually the promoters, there are different kinds of promoters. Like if you go to US, there are some professional promoters whose job is to promote the company, and once they have promoted the company, they hand it over to the people who are running the company and they exit. But if you look at India as such, promoters are equal, or most of the cases, the promoters are basically the founders of the companies who would want to stay back in the company, hold some lucrative position in the company, and carry on their work accordingly. Okay, and carry on their work accordingly. So that is how they are the promoters of in India usually work. But when you go to foreign companies, particularly, the concept of promoter actually started from US. Okay, so in US, these promoters, they're looking for lucrative offers. So they are usually selling the assets. They usually take a handsome reward in the form of cash or maybe shares in the company, and they exist. They are not, they usually don't form a part of that company. Okay. So I would like to close here now, is I've got a very important meeting to attend. So we will continue. And the PPT for the class, I will be sending once I complete this first portion. So within a day or two, I will be sending the entire PPT for the first unit. Okay.
Thank you, ma'am.
Okay. Thank you so much.
Thank you, ma'am. Thank you.